I did not write the brief. The brief was written by...
You signed the brief, though, didn't you?
Correct. I signed the brief.
When you sign a brief, you're testifying to the court that everything in it is true, right?
Yes.
Okay.
So
they're your words in terms of the court, right?
Well, you're correct, Senator Kennedy.
Okay.
I would never sign...
Tell me what you meant by assault weapons.
So I am not a gun expert, and at the time, that brief, I think, was about 10 years...
You were giving the court advice about, say, ban assault weapons. What is... You told the court you were an expert. Just tell me what you wanted to ban.
Senator, sitting here today, as I said, I did not write that brief. I was local counsel.
Sign the brief.
I understand. At the time...
Tell me what you wanted to ban. That's all I want to know, Judge.
I don't remember the exact definition of assault weapons in the ordinance that was at issue.
So you submitted a brief to an appellate brief. You signed it, and you don't know what. And you said abolish assault weapons, and you don't know what you wanted them to abolish.
Senator, at the time that I signed the brief, I read the brief. Because our Supreme Court required an Illinois bar member to sign the brief. I was not responsible for researching the content.
You were responsible for the brief.
Absolutely. And sitting here today, I do not remember the characteristics that were cited in the ordinance for the assault weapons ban. It's not an area of practice that I have specialized in. I'm sure 10 years ago, I could have answered your question.
And
but sitting here today,
you think you deserve to be promoted with this record?
Senator, I stand by my record. I stand by my record.
Senator Butler.
Thank you, Mr. Chairman. Congratulations to you and your...
A tense and revealing Senate Judiciary Committee hearing put a federal judicial nominee under intense scrutiny as Senate John Kennedy methodically dismantled the case for promotion. Kennedy focused on hard numbers, citing court statistics that placed the judge among the worst performing in the Seventh Circuit and near the bottom nationally for unresolved motions. His point was blunt: justice delayed is justice denied, and litigants pay real financial and personal costs when cases stall. The senator framed productivity not as a clerical issue, but as a core measure of judicial responsibility. What made the exchange especially striking was the nominee's repeated refusal, or inability, to engage with those metrics. Rather than disputing the data, the judge leaned on subjective claims about quality and courtroom presence, a defense Kennedy quickly undercut by noting that every judge faces similar workloads. The implication was clear. If peers under the same conditions managed their dockets more effectively, why should this record be rewarded with elevation? The hearing then pivoted from efficiency to judicial judgment and ideology when Kennedy raised a past Brady Center brief advocating for a weapons ban. Despite signing the filing, the nominee struggled to explain what constituted an assault weapon or what exactly was being advocated for, an answer that landed poorly in a confirmation setting. Kennedy framed the issue not as gun policy itself. Signing legal arguments while disclaiming responsibility for their substance raises red flags about accountability. That moment echoed throughout the hearing, whether the nominee approaches the bench with sufficient rigor, ownership, and clarity, especially when constitutional questions are involved. Lifetime judicial appointments demand more than good intentions. They require demonstrated competence and intellectual seriousness under pressure. At its core, this hearing wasn't about ideology. It was about standards. Productivity, preparation, and accountability are not optional traits for federal judges. They are prerequisites. The exchange served as a reminder that confirmation hearings are one of the few moments when judicial records face direct public examination. Follow Inside Capitol for unfiltered coverage of Senate confirmation battles, judicial oversight, constitutional debates, and the power dynamics shaping America's courts.
confirmation hearing, but within minutes, the tone changes dramatically. During questioning, John Kennedy confronts a federal judicial nominee with a series of statistics about pending court motions. According to the data he cites, the judge has more than 100 unresolved motions and ranks among the slowest judges in the country when it comes to issuing rulings. For the senator, the argument is straightforward. In the legal system, time matters. When court decisions are delayed, litigants continue paying attorneys, cases remain unresolved, and justice itself can be slowed. But the nominee pushes back, emphasizing something different, not speed, but the quality of judicial decisions. The judge argues that careful deliberation and thoughtful rulings matter more than raw productivity statistics. The exchange highlights a fundamental tension inside the judicial system. Should judges primarily be evaluated by efficiency and case management, or by the depth and quality of their legal reasoning? Then the hearing shifts again. The senator raises a past legal brief connected to the Brady Center to Prevent Gun Violence, asking the nominee to explain legal arguments that supported banning certain firearms. But when pressed to define the policy referenced in that brief, the nominee struggles to recall the specifics. That moment becomes the turning point of the exchange, because confirmation hearings aren't just about legal philosophy, they're also about preparation, ownership, and the ability to defend past legal positions under scrutiny. For senators deciding whether to grant a lifetime judicial appointment, those moments matter. This is Capitol Deep Dive.